So, on to week 5, where we're looking at consumer rights and the first sale doctrine. This is the second of our two-week focus on copyright law, and in this week we're going to look at the idea of licensing and what limits can be put on, particularly on the consumer's rights and interests through contract. So, if you found the previous, some of the previous weeks more oriented towards legal philosophy and the deep and meaningful parts of the course, this one really is focused on some of the legal technicalities, which might be more your speed. Which is not to say that it doesn't have an interesting and deeply philosophical core to it as well. So, what is the first sale doctrine? Back in the early days of print, there were attempts in the United States to limit second-hand book sale markets. And the idea was that if you could actually put a term in the contract of sale that said, and this was usually printed in the inside of a book, that you weren't allowed to sell it second-hand or give it to anyone else, then somehow you could use a contract to magically eliminate the second-hand book sale. When courts were faced with this, they had objections to it, obviously, and when they put these objections together, they called it the first sale doctrine. So it's a United States authority, but it's drawn on exactly the same principles that our law is drawn on. So I suspect it would be, it's never been really properly tested here, but it's certainly a strong argument. Anyway, the concept of the doctrine is that downstream rights are extinguished by the first sale. So you can license things that you lend to someone, and you can give them the conditions in which they give them back, and so on and so forth. But as soon as something is actually sold, all those rights are extinguished. So you can't sell something and keep one hand on it. You can't sell someone your car and then say, but I want it back every Wednesday night to use it. So, I mean, this is really, it's not so much a doctrine as just basically a focus on what offer of an acceptance, what a contract actually is. Anyway, so the first sale doctrine means that once you've sold a product, once you've sold a piece of IP, subject to the rest of the law, it doesn't mean that the consumer has open slather with what they do. So, for instance, they can't attribute it to themselves and those sorts of things. But you can't actually then say you can't sell a product second-hand. So, this is where licensing becomes important. It's where we have to go back and look at contract law again. And where this concept of downstream rights becomes very, very important. Now, when you see the readings this week, which you read the readings this week, you'll see that the context here today is more about computer goods. It's about attempts to control the second-hand market in video games, which is a serious market issue because there seems to be significant profits being made by JB Hi-Fi and EB Games in selling second-hand goods, where the original publishers are not getting any of that money, and they're a little concerned about that situation. However, as you'll see through the readings, simply putting in contractual terms prohibiting resale or controlling second-hand market isn't sufficient, and in fact putting in technological barriers to stop people reselling software is also a problem. Where this has become a huge problem also is in professional level software like CAD, the computer-aided design software that Autodesk produces, that all the big drafting and architectural plans are done on. And their problem is where they sell a student version at reduced cost, and then people then resell those to others, and whether they have any ability to actually control what happens with the student version and to say you can't resell it. This asks all kinds of questions about what licensing can do. I mean, as you'll see from some of the licensing agreements I've extracted in the notes, there's things you can do with licenses. You can regulate and define fair use in relation to IP. You can set some boundaries there. Whether they're enforceable or not is another issue, but it's a venue by which you can say these things are okay and these things aren't. This also sets expectations on the customer-vendor relationship. So you don't necessarily have to give a consumer a right, but you can indicate that this sort of thing is okay. Whether or not it's fair use, we're probably not going to litigate in that way. So it's an area, it's a very grey area in law, but it's an interesting way in which you can actually use the contract. And the Urban Threads is an interesting example of that one, to actually define your relationship between customer and creator in a fuller way. You can also use it to enable further creativity and collaboration by enabling people. It's not just necessarily about saying what you can't do, it's what you can do. And the Second Life licensing agreement is an example of that. But the question is, can you actually then transform the fundamental relationship between being a consumer product sale one to something else? And what some of the software vendors are trying to do now is change the entire relationship and say it's not actually a sale of a product, it's actually a rental. And in that way we can have control over what you can do with your product. And in fact, the Autodesk contract's quite remarkable. It says you can't even take the product out of the jurisdiction that you bought it in, which is an interesting little provision there. Okay, so the focus of the workshop today is an arbitration scenario. We're going with arbitration so we don't have to worry about the technicalities of the law, but we're looking at the actual structure of the argument. So arbitration's not bound by the law, but of course an analysis of what the legal situation is at least strongly persuasive as to what a fair outcome would be. To look at both sides of the argument. Of course, if there were two presenters this week, each would probably take one side. We'll see if that happens. But really we need, as a group, to focus on what the two sides of the argument are. And we also think about what role law has to play in ADR, because increasingly, I say increasingly, it's always been the case that most civil law has been done through negotiation, through arbitration, and outside of the courts, usually on the steps of the courts just before the hearing. So while in a law course we focus an awful lot on civil procedure, an awful lot of what happens in the courtroom, most of the time disputes are settled outside of the courtroom. So this is again an interesting example of looking at how jurisdiction clauses and arbitration clauses work, and also to talk about the role of new technologies, and particularly cloud-based technologies, because the technologies are now evolving to the point where there might be some argument that actually if you're not so much buying a product like you were when you were buying a disc, but if you're actually purchasing access to a product that runs on a cloud-based server, then you're actually then back in the realm of licensing a rental agreement. So it may be that the technology might actually change the nature of the legal relationship, even though we're sort of doing the same thing. So there's some very interesting issues there and questions to discuss.